Justice Kavanaugh?
What's the limit on that in terms of your answer to Justice Sotomayor? 50%, 40%, 30%, and what kind of guidance do you think we could give? Because one of the legitimate concerns of your brief and the amicus briefs are to give clearer guidance. What do you think the limit is on taking the political considerations into account in fashioning a remedial district that substantially addresses the violation?
Well, I think one of the limits, Justice Kavanaugh, is numerical, right? I mean, in Shaw 2, the court said that a 20% overlap was insufficient. In LULAC, less than 50% was insufficient. Here, we're in the neighborhood of 70%. So I think as a numerical matter, that's going to be one pretty clear guidepost for the lower courts on how closely a state is approximating the illustrative map. And I think the other thing is just to really assess why the state deviated from the baseline map. And I think that's one of the things where I don't know that there's any dispute in this case on both sides why we didn't adopt SB 4, we adopted SB 8. The sole reason, in Senator Womack's own statements, is SB 8 was the only map that would protect our high-profile incumbents.
So the rule I think you want is political considerations are fine to take into account in doing the map, the second map, and 50's kind of a floor on that.
I think so. I mean, this court has never spelled out what substantially addresses means as a numerical matter. And to my mind, if I'm between 60 and 80%, I think that's substantial, but obviously a judgment call for this court. Thank you.
I just want to be sure I understand your question to Justice Alito. Justice Alito asked you, if the Robinson decision was patently wrong, could it still be a good reason? And you said, well, if it was patently wrong, no, but we were obeying the federal court orders, this wasn't patently wrong. What is the point at which, because it's an odd situation, right, where the later district court has to essentially take as preclusive the earlier district court's determination of the Section 2 violation, right? But it's not entirely preclusive because you left room for the later court to say, well, that was patently wrong, so we're not going to follow it. What is the line?
So I think there are two ways in which it's not automatically preclusive, Justice Barrett. I think the first is, regardless of what the earlier court decisions say, when the state acts, it has to substantially address the baseline violation. So that's one way in which, if we failed to do that, if we adopted an SB 8 map that had only 20% overlap with the Robinson illustratives, then that's one way in which the VRA decisions are not preclusive here. We lose this case. I think the other way, and I think this is what your question was getting at, is that in the wildly wrong case, I think we just can't we can't dispute that there may be some case where objectively on both sides of the aisle everybody agrees that the court just got the law and the facts wrong. I think that's a case we have to give up, and we're happy to give it up. But barring that case, when a federal court, two federal courts tell a state what the law requires, to me, that means that there should be a very, very high bar in this court's precedence for second-guessing what those federal courts say. And I think you just leave that hypothetical out there as a potential odd case that may never arise, but we acknowledge that, it is out there.
I mean, is it also because of the position that it puts the state in here? I mean, it's not just a matter of your obedience to the federal court order, which I appreciate, you would be obedient to the federal court order, but it's also that if you had continued to litigate the Robinson If you had continued to litigate in Robinson, you risked having the court-imposed map. And so it's really your litigation risk that's part of the calculus here?
That's one risk, Your Honor. I think it's both litigation risk and political risk, because remember, if you look at page 601 of the Fifth Circuit's decision, they say, now that we have affirmed the district court on the merits, we don't doubt that the legislature might want to take this opportunity to draw a new map now. And here's a deadline, January 15th, 2024. You call that litigation risk, you can call that political risk, whatever it is, it's forcing the state to make a call.
Well, it's wrapped up together, yeah.
That's correct.
If you're going to lose, then you risk that the district court's going to impose a map on you.
That's exactly right, Justice Barrett.
Okay.